Hey guys, welcome to IP Series COVID-19 edition. So, what we do here basically is we talk about everything IP related, from copyright, trademark, patent, industrial designs, trade secrets, traditional knowledge, plant varieties, and also recent IP cases and development globally. Today's episode is going to be an interesting one. So, if you're new, please keep listening. If you're an old listener, thank you for always listening. And yeah, stay tuned. On today's episode, we will be talking about the battle of marks in a likelihood of confusion in a logo and a wordmark. So, as per tradition, we have two case studies. We have the Prepear against Apple Inc. and the Reelz against Reelz. So, this is what the confusion is all about. So, trademark as an IP can be in form of a name, word, logo, sign, symbol, slogan, smell that can be used to differentiate one brand from another brand. And the main thing about trademark is that it has to be in consistent use. It has to be consistently used for commerce. So yeah, just stay tuned and I'll give you guys a brief background about this case study for this episode. So, to our first case study, Prepear against Apple Inc. Prepear is a company owned by Natalia Monson, a food blogger with about 11 years in her portfolio, was accused by Apple Inc., a $1 trillion company, for using a pear logo which they claim is similar to their Apple logo, that it would hurt their brand because it has a minimalist fruit design with a right angle leaf. I mean, come on guys, do you agree? I don't actually. So now, if you listen to my Re Valentino case against the United States Patent and Trademark Office, where their rock stored spike application was opposed, this is almost like the same case. Now, in a trademark application, the final step before you are awarded a trademark certificate or issued a trademark for your mark is the opposition stage. Now, Apple opposed their peer logo application, which was published in late 2009. So anyone opposed to it can raise an objection, and that is how Apple Inc. came into the picture. Now, this only gained or became viral when iPhone Canada made a publication on the 8th of August 2020, and since then I've seen a lot of IP practitioners talking about it, giving their own perspective. So I'm going to give my own perspective from the Nigerian IP angle. So yeah, stay tuned and I'll share my thoughts on whether or not Apple has a case or doesn't have a case. But we'll see how everything turns out. So, what are the grounds for opposition of a mark? First of all, the person applying that has no intention to use the mark. It must be confusingly similar or identical to a previously registered mark. And in this question, the peer logo is not similar or identical to an Apple logo. The trademark is likely to deceive the public. That is not the case here. It is scandalous, immoral in nature, and likely to cause confusion. I see no confusion, really. The mark in question would contain a geographical name, no geographical name again. The applicant is not the true owner of the mark. I think it's pretty clear that Natalia Monson is the owner of the Prepear mark, and Apple Inc. is the owner of the Apple Inc. mark. So there's no confusion here as to who owns the mark in question. The trademark contains some restricted words such as patent, copyright, Red Cross, the use of the coat of arms of Nigeria, or names of chemical substance, and that's not the case here. So yeah, so who can oppose a trademark application? Any interested person, including the third party, may give notice of their intention to oppose a trademark application. Now, in order for your trademark to be registered, it has to be distinctive in nature. You can see this in Section 9 of the Nigerian Trademark Act, especially paragraph C, which provides that it must be an invented word. It must have no direct reference to the character or quality of the goods, and any other distinctive mark. Evidence of the mark distinctiveness is also required. Section 10 provides that the mark must be capable of actually distinguishing the goods or the services. So for a mark to be known, it takes a lot of work, investments over the years, IP registration based on the territory. So in order to enjoy legal backing and protection, and also prevent other people from using it. Now, from my research, I found out that Prepear already has already registered trademark in some countries, and the US was the recent one they were doing, and that was how Apple got to, you know, oppose their trademark application when it was published late last year. So trademark also can also be protected in some instances where you have used that mark for a very long period of time. Trademark protects the name, logos, design, signs, symbols of a mark, not the invention or the idea behind the product. Trademark is visual in nature. It's pretty obvious that the Pear logo is different from the Apple logo, and also not in the same class as the Apple logo. There is also not going to be an element or act of unfair competition. So because Prepear is not in the same class or line of business as Apple, there's not going to be any competition. However, and these are the elements of what can be classified to be an act of unfair competition. Causing of confusion, where you go into the same line of business just to cause confusion amongst consumers, discrediting your competitor, and also using misleading things to deter the consumers. Now, according to Article 10, apologies, Amelia, I can't help it. According to Articles 10b, B's subsection 3 of the Paris Convention, which is a treaty for the protection of industrial properties such as trademark, patent, industrial design, utility, model, service marks, trademark, geographic indication, and unfair competition, which Nigeria happens to be a party to since September 2nd, 1963. IP protection is also an investment. So what I just stated as the elements of an unfair competition is what you find listed in Article 10b of the Paris Convention. So IP protection is an investment, which is why you see well-known or famous brands or marks being protective, somewhat aggressive in their actions, which can be termed to be bullying. I know last year I did talk about the Haribo case, but that was kind of a valid instance. But we've had instances, or I've seen or read instances, where a big brand wants to, intimidate a smaller brand into giving up their trademark, and at the end of the day, they might end up buying up that company or going into some sort of partnership. But that is not the case here. So what are the elements of a trademark infringement? So the mark infringed must have a positive image or reputation, just like how Apple has its own positive image and reputation, the eyes of the consumers, that the infringing mark could damage their goodwill and reputation. That's not the case here. That they have the exclusive rights as the owner of the mark. So another question I think people want to know is, can another person in another territory or region or geographical area use the same trademark as you? Yeah, sure thing, they can. So far as it doesn't overlap, they can do that. However, under the common law, a trademark owner who chooses to expand to your territory um, where you have the similar mark, they can, use that trademark in that region, even if you have been using it before, from an earlier date. So now in this Prepear and Apple Inc. case, I would say this doesn't apply here, as a pear fruit is different from an apple fruit, even if the pear fruit has like a right angled leaf. So yeah, so under section 17 of the Trademark Act, it provides that um, in a scenario where you need a preliminary advice on whether or not your mark is distinctive in nature, you can make an application to the trademark registry or registrar, uh, stating that you wish to apply for an advice as to whether or not your trademark appears to be capable of distinguishing it from another. The registrar shall have the power to give the advice asked in the application. Now, subsection 2 provides that if the answer is in the affirmative, that is, if it says yes, or confirms or consents or supports it, this must be done within 3 months of the advice given, and the registrar, after further investigation, can give a notice of his objection, as stated in section 18 sub 2, to the acceptance of the application, on the grounds that the trademark is not capable of distinguishing the applicant's the goods in question, and the applicant shall be entitled to a refund of any fee paid in filing that trademark application. So I think, again, this is one of the reasons why you should hire an IP lawyer in question, because when you're doing your IP application, other than doing the search, you can also do a letter, to the trademark registrar, asking whether your mark is really distinctive in nature, so you don't go ahead to waste money. But the law provides that where you've gone ahead to do that, your funds, your money can always be refunded back to you. This is based on the notice of withdrawal of the applicant, which has to be done within a prescribed period of time. Now, section 20, which talks about opposition of marks, states that an opposition takes place within 2 months from the date of the publication, and notice should be given to the registrar. Now, in this Apple Inc. case, the opposition, the publication of the opposition, the publication was made in the late 2019, and Apple made an application to oppose it that same period. So yeah, so take note that steps, one of the this types of opposition is very crucial when it comes to trademark application. So don't let any trademark agent deceive you that you can get a trademark certification in less than 3 months, because the opposition publication lasts for 2 months, and I think that's like a general thing. So finally, my final thought, I do not see any resemblance in Prepear logo, which happens to be a meal planning service company, and the Apple Inc. Apple logo, who happens to be a tech giant. But we would want to see how the whole opposition plays out at the end of the day. Currently, there's a petition against Apple called Save the Pear from Apple, and it has over 23,000 signatories on this petition, asking just to draw more lives and make sure that people are aware of what is actually going on. Because if the iPhone Canada hadn't made that publication, I bet a lot of people would not have known that Apple was actually challenging a fruit logo, a pear fruit logo company out there. But yeah, hopefully everything is in favor of Natalia Monson's company. So yeah, that's it for the first case. We'll get into the second case after this break. Now to our second and final case, the case of Reelz with S against Reelz with Z. So this reminds me of the Nigerian entertainment case between Kiss, that's Kiss Daniel, against his former record label on his name. So he changed his name from Kiss to Keys. So this is kind of like this. So over the weekend, Reelz, that is Reelz now with the Z, which was launched in September 27th, 2006, and has over 50 million reach in the US, says that the Instagram new short video feature called Reelz, that was launched on the 5th of August, infringed on its name and long-standing trademark. So if you recall, I said trademark is anything, is a source identifier. So it could be your name, your logo, your sign, your symbol. So the initial case, that is the Prepear and Apple Ink cake, was about the logo, but in this case, we're talking about the name and its trademark basically. So the network parent company called Hubbard Broadcasting says that Reels of Instagram has infringed on its goodwill and is likely to confuse consumers, and is suing them for trademark infringement, trademark dilution, and unfair competition, and is also seeking for an injunction banning Instagram and Facebook from using Reels, and also damages in any amount that is to be determined by the court. So I'm going to give you guys just break down what it is exactly that they are suing for. So we've already established that trademark is a source identifier. So what is a trademark infringement? Now this happens when someone uses the mark of another person for commercial purposes without the consent or permission or authorization of the trademark owner. And this is also the case for every other IPs out there. So now another way for a brand or a trademark owner to expand or grow itself is by going into exploring branding strategy, by adopting strategies for different market approach in the same country. Now remember I said Hubbard Broadcasting is the parent company of Reelz Channel. So in this case, Hubbard Broadcasting has explored product extension branding, with it being the parent brand and Reelz Channel being the sub brand for a new brand extension. So I'm going to look at the other aspect of what they're suing Reels for. So I do think that there's actually a likelihood of confusion, because even in the pronunciation, Reels again Reels. So it might seem like it's a tongue thing, but it's not. It's just that it's just too similar and confusing. And the only difference is the letters behind the reel. So Reels, which ends with the S, is a new short video feature that Instagram created. I know I've done like 2 videos of it already, and I'm sure a couple of us, or most of us, have seen some Reels video on Instagram. While the Reelz Channel's own ends with a Z. So yeah, what are the criteria, or what can qualify as a trademark infringement? So in a case where there's likelihood of confusion, any mark that attempts to confuse or cause confusion among the consumers and causes damage to the trademark owner, is done in bad faith, it's said to be a criteria for an infringement. On trademark dilution, according to INTA, which is the International Trademark Association, it defines dilution as an act that weakens the uniqueness of a famous mark. So in this case, where Reelz, as the Reelz channel is suing Reels of Instagram for trademark dilution, they're basically saying that Reels using their name and weakens their brand basically. And this is different from a trademark infringement, because in a trademark dilution, the infringer uses the mark connected with a goods or services, but not with the aim to compete with the famous mark. So Reels of Instagram doesn't have any business, or does not even want to compete with Reels channel, but rather just want to weaken the mark itself in question. And the aim, like I said, is not to compete with the famous mark, and this, which is why this deserves a level of protection beyond the standard of likelihood of confusion, which is like the basis of a trademark infringement. So for a trademark infringement, the difference is in a trademark infringement, there's going to be a likelihood of confusion, while in a trademark dilution, the main game or aim or goal is to weaken the uniqueness of that particular brand in question. So what are the elements of a trademark dilution? Fame. So the mark in question must be famous, just like Reelz Channel. Its mark is famous, and which is why it came after Reels of Instagram stating that I wanted to dilute or weaken its mark that's already existing. Necessarily showing the second one is necessarily showing that the owner of the famous mark must exhibit or show proof of likelihood of dilution rather than actual existence of the dilution in question. Then the final one is that it protects the strength of a mark for the owner from the entity that is Reelz Channel, Reelz Instagram, that would weaken the ability of Reelz Channel to identify and distinguish the goods and services. So types of dilution, you have blurring. So for instance, now when we're talking about blurring as a trademark and dilution, in this case where Reels belonging to Facebook and Instagram uses Reels channel, which is identical to Reels, that is connected to a goods or services, even though it is completely unrelated to the plaintiff's good. So like we said, Reels of Instagram is a short video feature that was introduced on Instagram, while Reels channel is a broadcasting sub-brand under Huba Broadcasting. And the aim here is just to weaken Reels channel. Um, and like Section 9 of our Trademark Act provides that in order for you to register a mark, the mark must be distinctive in nature. And Reels channel, when you registered, its mark was a distinctive one, which was why the application was approved. Another one is tarnishment. In this case, the third party uses the mark in an inappropriate way, that is a sexual or offensive way or content. So what is of unfair competition? What is unfair competition? This is like a dishonest practice where the national law sets the commercial and legal environment by trying to ensure that there's fairness in competition, and as a result complement the protection of intellectual property rights. Examples of unfair competitions or unfair acts would be misleading adverts, violation of trade secrets, which are usually not dealt with by specific laws. Unfair competition law is meant to give protection that no such law can provide. So these are the three. I've touched on the three areas which Reels channel was suing or is suing and Reels of Instagram for. So for me, my own conclusion is that there's a huge likelihood of confusion, and I hope Instagram, the founders of Instagram, the owner of Instagram, the current owner of Instagram, does a good job in, either by changing their name or coming up with something else, another feature that will not infringe or dilute Reels channel IP. So yeah, I think I've covered everything. I would say I've covered everything. So if you really learned something new today on likelihood of confusion with regards to trademark, do let me know. Send me an email, do a comment. If you're just joining, this is the first podcast you're listening to, please share your thoughts. As for the listeners I already have, thank you guys so much for always consistently listening to me talk about IP. The goal is to create awareness and educate people that is creatives and innovators. So yeah, I think that's it for me. Until the next IP series, stay safe and have a nice day, guys. Bye.